Okay, if we could bring Ms. Rielly out, please. Good afternoon, Ms. Rivers. Can you hear us here in court?
Good afternoon, Judge. How are you?
I'm well.
Judge, can we have the defense make sure their mic's on and they're totally out of view of the camera?
Sure, we'll do that. That's okay. We'll get everyone situated and make sure that's all working.
Okay, thank you.
Can you hear us all right?
So you need, if you'll put your finger in the little well, then let go, it should turn green. Excellent. Now the answer is yes. Okay, this is case 20 SC 176922, State versus Lauren Rielly. Ms. Rielly is in court with her lawyer. We have with one of her lawyers. We have online a different lawyer for, I think, a different case.
Yes.
Mr. Clement.
That's correct, Your Honor.
Okay. Not involved in representing Ms. Rielly in connection with what I'm going to call the home invasion case.
Yes, that's correct.
Okay. We have Mr. Abate here for the state. Ms. Rielly, I'm Judge McBurney. We may have met once long ago. I typically haven't required you or your lawyer to come to court when we've been having some of the not particularly substantive proceedings on this case involving co-defendant Pritchett, and I think the other name is Robinson. We've been trying to figure out what exactly Mr. Pritchett wants to do. And poor Mr. Robinson has been cycling through some attorneys. He had retained counsel who withdrew at about the 11th and 3/4 hour. And then it's been hard finding an appointed lawyer. These are complicated times to get conflict lawyers. You've always had a lawyer who has advocated strongly for you, but you haven't had to be very much involved because for a while it was relayed to me that the focus of the state's trial prosecution, if it went to trial, would be Mr. Robinson and Mr. Pritchett. We're here today because a few things have changed for you. And I'm going to let your lawyer do the advocacy, but I have revoked your bond because of your arrest in late May in connection with completely different allegations. But you were on bond in this case and have been for many years. And then there was this fairly serious arrest and situation. I think it was a bit more serious for Mr. Pierce, the gentleman who was in the front seat of the car you were driving. We're not going to talk about the facts of that case today, unless your lawyer chooses to. I'm certainly not going to ask you about it. But that arrest and the nature of the charges prompted me to revoke the bond. You're entitled to a hearing on that decision. I can make that decision preliminarily to sort of freeze the situation, which I did. I know there was a little bit of an issue with you trying to turn yourself in, not your fault, but the jail wouldn't accept you. I think we fixed it. I know we fixed it because I saw what door you came through. But we do need to go through this process of having a hearing on the decision I made so that I can undecide it if I'm convinced by your lawyer that that's what I should do. Or I can reaffirm the decision I made to revoke your bond until we sort out what's going to happen with you in this case, by which I mean the home invasion case. I don't have anything to do at this point with the new charges. I'll let you know that if the state hurries up and indicts that new case, it will come to me because new cases go to a judge who has an older case with the same defendant. If it's not indicted before we resolve this case, then it will be randomly assigned to some other judge. But it could well be that your new charges come here. That's not a coincidence. It's by design. So one defendant, one judge, we'd be working out all your stuff at once. But again, that's only if the new charges are indicted before the old case with the home invasion allegation is not resolved when they're indicted. So that's where we are. Mr. Abate, I'm going to start with the state. It was Mr. Hiles, colleague of yours, who shared with me the news that Ms. Rielly had been arrested. I'm the one who decided to revoke the bond, but presumably that's something the state is still advocating for. So I'll ask you to share what you want to share, and then I'll certainly hear from Ms. Rielly and her legal team.
Yes, Judge. So,
And I'll make sure your microphone's on too.
yes, Judge. it is.
Great. Okay.
In speaking with defense counsel, we both discussed proffering, I guess, the evidence that would be used in the hearing today. We had Deputy Jermaine Moore here earlier, and we've since let him go based on that conversation that I had with counsel. So I can proffer what was proffered in the motion to revoke bond. Now, I'll take some guidance from the court.
Sure. No, we should get on the record the proffer, and then defense can fine tune it if they think that something has been misstated, overstated, whatnot. Deputy Moore would be one of the two officers involved in the traffic stop, or Deputy Moore is someone who's been investigating since then and relayed to you what he or she learned from the responding officers?
He was the deputy who was on duty that night who initiated the traffic stop of Miss Rielly and her occupant at the time.
Okay, so he's an eyewitness law enforcement person.
That's correct. Yes, Your Honor.
Got it. Okay.
So on May 30th of 2023, investigator Moore, who works with the Sheriff's Department here in Fulton County, was on duty and at the intersection of Northside Drive and Marietta Street. He was actually directly behind the vehicle that he later learned was being driven by Miss Rielly. It was a gray Mercedes GLE. They were both stopped at a red light. At the time the light turned green, Miss Rielly was in a turn only lane, and instead of turning right, what she did was go straight forward and then cut off. I believe it was a MARTA transit bus. And at that point is when, due to the improper lane change, a stop of the vehicle was initiated by Investigator Moore.
Investigator Moore was in a marked patrol car, or at least something that had emergency lights that he could activate?
That's correct. Yes, Your Honor.
Okay.
And upon initiation of his emergency lights to pull the vehicle over, Miss Rielly pulled over onto the side of the road. He at that point asked for her driver's license and registration. And at that time, he smelled a very strong odor of raw marijuana. He called additional officers for backup and placed Miss Rielly or detained her in handcuffs. And at that time was asking the passenger of the vehicle, who he later learned to be Mr. Reginald Pierce, to step out of the vehicle. He was uncooperative at that time and actually attempted to flee. They had to use several different ways to gain control and custody of Mr. Pierce, which include using their taser multiple times to finally get Mr. Pierce into handcuffs, Your Honor. At the time that they were able to get the situation under control, they did a probable cause search incident to arrest of the vehicle. When they did, they found looks like 57.5 grams of MDMA, 62 grams of marijuana, 239 grams of oxycodone, 46.5 grams of Percocet, and 575.5 grams of promethazine inside of a black book bag that was it was behind the front passenger seat of the floorboard. Also, as they were doing a canvass of the area where the car had been stopped, they found a black Adidas bag that had approximately $10,020 in cash and another clear bag of what's suspected to be marijuana. It was a clear bag full of green leafy substance. Upon speaking to Ms. Rielly, she was read Miranda warnings, and she agreed to speak with the investigators who were on scene. She actually told the investigators that the car or that the Adidas bag had been hanging outside of the vehicle she was driving, and where they found it is where she placed it. I guess while she was in handcuffs, she was able to maneuver her hands to the front side of her body, and then was able to get the bag and place it close in proximity to the vehicle where it was found. As the investigation continued after the arrest, inside of the bag was two cell phones, and there was also a cell phone found in the vehicle. Investigator Moore was able to get a search warrant for those phones, and actually was able to extract contents from, I believe, all 3 of the phones. But the messages that I would bring to the court's attention today, there was a phone that belonged to Mr. Pierce, and Mr. Pierce had been texting with his mom earlier in the day on May 30th. And during that text exchange with his mother, he asked his mom to put all the pills, the cash, and the gun inside of the black bag. And that as soon as she had done that, to contact Miss Rielly to make the exchange. Mr. Pierce was out of town. He was flying into the Atlanta airport, I think later that evening, around 6 o'clock, a little bit, about an hour, 2 hours before him and Miss Rielly were arrested. But he sent a screenshot to his mom of Miss Rielly's contact information and told her to contact Miss Rielly so they could set up a meeting spot for the exchange of the narcotics, cash, and the gun. At that time, mom said, okay, I'm going to tell her to meet me at the McDonald's at the Virginia Avenue, or in the Virginia Avenue area, which is close to the airport. And after that was completed, mom actually sent a text message to Mr. Pierce before he boarded his flight saying, I met with Lauren, and she has all of the items above. So, Your Honor, that was the basis for the motion to revoke Miss Rielly's bond. I'd also bring to the court's attention is Miss Rielly is, I believe she had an ankle monitor at the time of her arrest, or she was supposed to, and she was actually on house arrest. And she was only allowed to leave for court, medical, and other appointments related to her case. And it appears she was not actually doing any of those things at the time of her arrest as well. She told the officers that she had just picked up Mr. Pierce, and she was just taking him, I believe, to drop him off at dinner or a restaurant, which is not one of the things that is outlined in her bond. I think it was done by Magistrate Court Judge Ashley, basically of one of the 3 exceptions that she's allowed to be out, Your Honor. So that would be the state's proffer at this time.
Okay. Mr. Keller here, what do you want to add to that? And anything else?
So both general argument and as to the proffer. All right. So as to the proffer, as obviously this is a very early stage in the proceeding, we don't have discovery. We haven't been able to, I haven't seen anything as far as cell phones, search warrants, any
You're
of that.
flying blind.
Right, exactly. And so that does seem to be a correct recitation of the police report. The report was attached to the government or to the state's motion to revoke bond. Aside from the additional regarding the cell phone, which was not contained in the report, I have no reason to not believe on that, other than just to point out, I think that there are still, this is obviously going to be a case which is either going to be part of a joint resolution of the entire matter with both cases, or it's going to be one which is litigated by Mr. Clement once he's received discovery and that case progresses. But I do think that there are some possession access issues just from the recitation of facts without going further into that. So just generally about Ms. Rielly and the background of this case, she was originally arrested September 2019, was granted bond by Judge Ashley in December of 2020. Since then, she has been granted immunity for testimony from an order signed by Your Honor on April 15th of 2022. In anticipation of what was I believe it was the first trial setting date of this case in April of 2022. We met with and had 2 proffer sessions with ADA Parrish, who was handling the case at that time, subsequently left the office. In anticipation of a trial date sometime this year, we have been in regular communications with ADA Hiles. We've had multiple proffer sessions with ADA Hiles as well. We've been in communication about both her testimony, about her status in this case, about the ankle monitor situation. We're acknowledging entirely she was still on house arrest. We had not come to the court for any modifications as to that. At this time, she would not have been permitted to be driving as she was here.
Do we know, I meant to ask Mr. Abate, but the cell phone thing was something new. That wasn't in the police report, like you said. So I got distracted by what had been extracted from the phones. The car that your client was allegedly driving on May 30th, whose car? If you know.
It is, she was the occupant and driver of the car. I believe the title is her mother.
It's a family car.
It's her family vehicle.
Got it. Not a stolen car.
No, there's no issue as to the ownership of the vehicle.
Got it.
Yes.
It would be a car that would not be problematic had Ms. Rielly been driving to the doctor's office or to meet with you or to come to court. It's a car that it was otherwise fine that she was driving, assuming she's got a driver's license.
Yes, absolutely.
Okay.
No issue with that.
Yep.
And so also, as part of our continued ongoing discussions with the DA's office, there have been a number of things that we've discussed, specifically her mental health history. Records have been shared as to that. There's been an evaluation. That evaluation has also been shared with the DA's office, specifically as to borderline personality disorder, which manifests in a lot of impulse control issues. Dr. Matthew Norman did the evaluation. All of that has been shared with the state. There's also been incidents that the state actually, we kind of mutually made each other aware of regarding her as a domestic violence victim that have occurred while she's been on bond. There was a report that ADA Hiles provided to me about a May 31st, 2022 incident with body camera. The officer comes, the person has already left at that time, but there are clear visible injuries and damage all throughout the property. So I just wanted to provide the court some of that context as to Ms. Rielly generally. In asking that she be allowed to remain on bond and that she remain on bond leading up to what will eventually be the testimony in the trial of the co-defendants in this case, and then a subsequent, in all likelihood, speedy resolution of this matter for Ms. Rielly.
Okay. Nothing has been speedy about this older case, not through anything you or Ms. Rielly have done. And in fact, for several years, it seemed like things were going relatively smoothly for Ms. Rielly, and I don't remember the name of the other.
Kalish, Ms. Kalish.
Ms. Kalish, that's right. Mr. Zimmerman's client. That neither Ms. Rielly nor Ms. Kalish was needing to come to court for things because of the status you've described that it sounded like they were in. This changes things a bit for Ms. Rielly. She has now another set of charges that she and Mr. Clement will need to navigate. I agree with you that in the end, it probably will be some type of joint resolution, whether it's dismissal of the other charges, if further discovery shows there were some issues with the stop or the search or whatnot, or like you said, it would be a global resolution. My concern is Ms. Rielly's well-being between now and that resolution, as well as the general safety of the community. It sounds like there was a firearm in the mix. No one got hurt. Mr. Pierce is not Ms. Rielly, but it sounds like it was a little problematic when law enforcement tried to interact with Mr. Pierce. And again, it's fortunate that no one got hurt in that setting. But what this shows me is that Ms. Rielly, what shows me two things. One, the ankle monitor wasn't doing what it was supposed to do. Again, not Ms. Rielly's fault, but I'm not quite sure. Maybe it had been enough years that the ankle monitoring company just stopped worrying about it, or because Ms. Rielly was able to leave home for certain things, this was a non-event in their eyes. But one wonders if there have been other situations where if people had just looked at the to and the from, everything starts at home, but the destination is a gas station off Virginia Avenue in College Park, as opposed to a doctor or your office or the courthouse. Again, not faulting anyone for that, but these allegations are such that I think that the safest way and most certain way to ensure that Ms. Rielly isn't put in a dangerous situation or a situation where she might accrue additional charges is to keep Ms. Rielly where she is now. The new set of charges are also serious. They are much more preliminary than an indictment. But the state's ongoing investigation has made it more complicated for Ms. Rielly rather than less. The information extracted from the cell phone, which you have not had a chance to look at, nor has Mr. Clement, connects Ms. Rielly more, in my opinion, to the facts and circumstances of the drugs and the gun and whatnot, than I'm just driving a guy who's a friend or he paid me $50 to drive him somewhere. I think that it connects her more to the underlying activity, but that's not being proven or disproven at this juncture. It to me is sufficient that I am going to maintain the revocation with this caveat, as Mr. Clement works with both the state and Ms. Rielly. If the discovery and people's understanding of the facts and circumstances of the May 30 arrest evolve in a direction away from Ms. Rielly being connected to it, anything more than being merely present, we ought to have another discussion. And I'm happy to do that. But assuming that the evidence trends in the direction that Mr. Abate described, and that I appreciate you're not in a position to rebut right now, but I invite you to rebut it as more information comes, either to you directly or through Mr. Clement. But short of that, Ms. Rielly is going to stay where she is with no bond in the 20 SC case. We do have this set down for a hearing. It was to be just for Robinson and Pritchett. Obviously, all the defendants are invited, but it's mostly to figure out how we're going to manage Mr. Pritchett and representation. But I think there may have been a motion filed in Mr. Robinson's case. I'm not sure, but it, at a minimum, was a status check to see. That's looks like Mr. Hiles has filed a that's what it is. It's 418 motion. So we need to work through whether in at least if it's Pritchett and Robinson who go to trial, whether some other acts come in as to Pritchett, maybe Pritchett and Robinson under Rule 418. And we have to have a hearing on that. So that hearing is 27th. So that's soon, not next week, but the week after. And my goal through that hearing is to say, great, then let's set this down for a trial date. Not in the winter, but in the next couple months. And that will obviously affect Ms. Kalish, but it will certainly affect Ms. Rielly. And I just wanted her to understand, you to understand, Ms. Rielly, it's not that, oh man, it's been 3 years since this indictment. So what does that mean if I have no bond? You have had your bond revoked at the tail end of this overly long period, partly caused by COVID, and then caused by some representation issues for Robinson and Pritchett. But I fully expect the case to be tried or otherwise resolved this summer for you and the other 3 defendants. So that's where I am now. We can and will revisit upon motion from the defense, if in that motion you set forth at least somewhat basically what the changed circumstances are. We've got more discovery. The state is taken back some of the things that it thought were true based on Investigator Moore's investigation, et cetera. Okay. Mr. Abate, anything else on behalf of the state?
Only Judge, before I came here about an hour ago, I called A&A monitoring, requesting the monitoring report from Ms. Rielly, because I was a little confused as well as I read the report and then read your order and the order from Judge Ashley, where she was to be on house arrest. So it just seemed interesting as well to me that it seems as if the monitor is just another piece of jewelry. So. Right.
And so much time passes, sort of like pretrial services, where they say after a while, we're not going to supervise anymore. You know, our role is pretrial, not infinite. So if we need to fuss at A&A a little bit, we can do that. We shouldn't have to wait this long with someone stuck on an ankle monitor and house arrest. That's not a Ms. Rielly caused issue. But I will be interested to hear what your review of the records show.
And I will work on getting Mr. Clement as well as counsel here today before your honor. I never want to mispronounce his last name because I'm not good at it. But I will work on getting everybody the discoveries, especially as it relates to the extractions that were referenced today.
Okay. Mr. Kelleher, while I have you here, you may not have been as focused on the discovery in the 20 SC case because of your client's expected outcome in the case. Do you have any concerns about not having all the discovery in the case? I know it involved a bunch of, I'm assuming it came from people's phones, but one of the reasons Mr. Robinson's hired attorney rolled off was not being able to navigate lots of Instagram stuff, just not being facile with it. And even though Mr. Parrish, it was the Parrish era, said, I will sit down with you, I will click through so you can see, here's Mr. Robinson posting this or showing that. That wasn't going to go anywhere. But it's the same universe of discovery. I don't worry about your facility with that, but I do want to make sure you feel like you have everything, because I haven't focused much on you or Mr. Zimmerman when I've been making sure that lawyers are ready to go, or Mr. Pritchett by himself is ready to go for trial.
So there was an issue to that we were able to just resolve just through communications between myself and Mr. Hiles, and it wasn't anything we needed to bring to the court's attention. To the extent that there were any deficiencies with that years ago, all of those have been resolved now.
Good. Okay. And by far, my preference is reach out to the prosecutor. I'm here if you get no response or an unacceptable response. Not my experience with Mr. Parrish. It's gone elsewhere. Not my experience with Mr. Hiles. So I wasn't asking because I thought you were being given the runaround. I just wanted to make sure if you had let this file rest, because for 2.5 years, your client was doing her thing and staying out of harm's way, in theory, then you're going to need to resurrect it a little bit if you're going to try to sort things out. And it may be that Mr. Hiles wants to resolve Ms. Rielly's case in advance of her testifying. Sometimes that's cleaner for the state if she's going to be testifying in a trial in the 20 SC case. Sometimes the state likes to leave it open. That's kind of complicated for jurors to work through because they don't know how to judge the impact that has on a witness, and what will they get, and does the amount of testimony affect that? But that's a state decision, not a you or a me decision. But it sounds like you feel like you've got everything to which you're entitled, and you won't be a source of, we can't move forward because I'm still trying to figure out how the Instagram stuff works.
No, I've been in regular communications with Mr. Hiles over the past few months regarding this case and where it's going. It's
good. Probably in particular over the last few weeks. Yes. Okay.
Yes, ongoing. And there hasn't been, to the extent that there ever were any issues, we quickly resolved them between ourselves. So.
Good. Okay. Ms. Rielly, do you have any questions about what we talked about? Not substance, but procedure. In other words, what's coming next?
No, sir. I just would like my ankle monitor off if I am going to sit.
Yes, that's a fair request. I don't know. I guess what I'd ask you to do, Mr. Kelleher, is reach out to A&A.
Yes, they were just waiting on the outcome of this hearing before they took any action.
Got it.
So I will just let them know what's out of here, and
they should take action.
Right, they'll coordinate.
Okay, perfect. You don't need it, and so let's get it off you, and maybe the color of your skin underneath it can start to match the color of the rest of your skin. I'm guessing that's been on for a while. All right. Anything else, Mr. Body? You'll let Mr. Hiles know what happened?
Yes, Your Honor.
Okay. And the 27th will be interesting. Anything else from the defense?
Not on behalf of Ms. Rielly.
All right. Thank you so much.
Thank you, Judge.
Does Ms. Taylor still represent Mr. Robinson?
That's a negative.
Yeah.
Who is it?
So is Ms. Rielly going to be brought over on the 27th?
If you want her to, it wasn't the things to be litigated involved Robinson and Pritchett. So I wasn't planning on having Ms. Rielly here, and Ms. Kalish wasn't expected to be here either. why don't you talk with her and with Mr. Hiles?
Yeah. We got it. Yeah, so I think to the extent that we're just doing status and as to Ms. Rielly, that we would need to bring her over for that, that I'll just be present on Zoom along with
Yeah.
Mr. Zimmerman so that we can.
It will certainly be zoomed. And again, the only substantive things will be 418 Robinson, represented by Ms. Mignot, and Pritchett represented, most recently it was by Jesus. So we'll have him here and we'll figure out how that's going to go.
All right.
Okay. Thank you both.
Thank you, Judge.
Good to see you, Deputy Hudson, all week long.
Yes, sir. Grant gets discovery if there's something different.
Didn't you have the case that involved the